Hey guys, George Roddy. Okay, here is the purchase and sale agreement that Tim and I want you to use each and every time. Now, we've produced a couple different videos depending on the type of seller and situation, but the first one, and most likely the most prevalent type of contract that you're going to write, is one where it's an all cash offer. So what I want to do is take a few minutes and walk through line by line, paragraph by paragraph, how we want you to draw up these contracts and control real estate and give yourself an opportunity to shop this contract around and find that end buyer or end investor that you can sell this all cash offer to. So let's start. Now I'm using zip forms because I'm a licensed agent. I have zip forms on my computer, and so you guys are most likely not going to have a way to type this up. You're going to have to handwrite it. Now we're working on producing these where you can do the same thing that I'm doing on the screen, but until that time you need to handwrite what I'm going over right now. So the first thing is I want to talk about the type of property. This contract is not for commercial properties. This contract is not for condominiums. So it's for single family dwellings or residential properties. If you want to buy a condo, you're going to need to use a different contract. If you want to buy a commercial property or land, you're going to need to use a different contract. But 99% of the time, you guys are going to be locating distressed or motivated sellers that own residential real estate. So let's go through this. Page 1, and by the way, this is a 9-page document. So page 1, let me click off this. Page 1, paragraph 1 are parties. The parties to this contract are, you've got the seller's place and the buyers. So what I'm going to do is I'm going to click here and put Tim Harridge is the seller and Jennifer Harridge. And then now it goes to, when I tab, it goes to buyers. And then I'd put George, let me get this out of the way, George Roddy. And then what I want you to always do is put and or assigns. Okay? Because you want the right to assign this contract to an end investor. And whether you discuss this with the seller or not, but this gives you, and how I typically put it is, I might sell this property to another one of my investors. I might put this property into a LLC or a family trust. I'm most likely not going to title this property or buy this property in my name. That's why I put and or assigned. But what that gives you the right to do is to assign or sell this bundle of rights. And really what a contract is a bundle of rights. So we've got the seller and the buyer. And let me back up a little bit. How do we know who the seller is? What I would do is I would go to the appraisal district and see who they show as the owner of record or owners of record. Then we come down to paragraph number 2 is the property, and I'd put lot 2, block A, and let me cap everything just so it, what you should do is just kind of capitalize everything, come back here and put A, and then I can put Bent Trail Estates, whatever the subdivision name is. And the city of, let's put in Dallas, county of, let's put in Collin, and then known as, we could put the address of the property, 4851 Keller Springs Road. And that's it. So you got the lot, the block, the subdivision, the city, the county, and then the actual citizen or the physical address. Then I scroll down and it comes down to exclusions. Now, when you're walking through the house and you're sitting down at the table and you're writing this contract up, you need to ask, everything that's attached to the property, I'm assuming, is staying, unless you tell me otherwise. So if there are accessories, you need to talk about, like the fridge is not attached. That can be transferred, but the stove, the microwave, the dishwasher, I need to know about ceiling fans or chandeliers and things like that. Anything that the seller does not want to stay with the house, we need to put in here. So it's kind of like the foyer, light fixture, because maybe they want, it's an heirloom and they want to take it with them. That's what you would put in exclusions. And if it's not excluded and it's attached to the house, then it's supposed to stay with the property. So that's paragraph 2. Now we come down to paragraph 3, and here's where we put in, you're writing an offer, an all cash offer. And the reason why you're doing that is because there's a ton of equity. And you've already talked to the seller and they told you, look, we need $75,000 and that's going to net us enough to get moved on with our lives. So what you're going to do is draw up and put 75,000 right here. And then you're going to leave the financing, because we're getting this property under contract all cash. We're going to put 0 or leave it blank as financing, because bottom line is we're going to find an investor who's going to pay us 78, 82, 85,000. And we've got it under contract for 75, and we'll get to assigning the contract in another video in this module. Then we come down to financing. Because it's a cash offer, we're not going to fill in anything in here. 4A, 4B, and 4C is left blank. You could actually draw a line through this. Just kind of, when you're drawing this up, just draw a line through this just on 4, because there isn't any financing. So that's really it on page 1. Now, you're going to hear me say this at the bottom of each page. That's where you as the buyer need to initial, and the seller or sellers need to initial. So every page needs to be initialed and or signed. The first, let's say the first 7 pages of this contract needs to be initialed by both of you guys. And then on page 8, it needs to be signed. And then page 9, nothing really needs to be signed. Well, I take that back. I'll go through page 9 here in a little bit. But definitely pages 1 through 7, at the bottom right here, it has buyer, put your initial, and sellers, get both parties, okay? You can't, one thing is that a husband can't sell the house without a wife. If it's a married couple, you've got to have both parties under contract, so to speak, or on board. So if the wife is on board but the husband isn't, you don't have a deal. You must have all interested parties or all owners to sign this contract. Page 2, you can see up here that it automatically puts in the address if you're using zip forms. But again, you guys are handwriting this, so you need to put the address up here. Then earnest money, paragraph 5, let's talk about this. Earnest money is not a requirement. So you don't have to put earnest money. Now, I will say that if you're making an offer to, say, a bank-owned property, you can't leave that blank, because the bank is, this paragraph 5 really sums up and says, how serious are you? And I think that's a little misleading, because you're very serious in buying, but you don't want to put up any money to risk. So, what I would say is, here's what's very common. If you're writing if you're writing an offer and it's with a real estate agent, usually 1% of the sales price. So the sales price is $75,000. It's very common to put $750 right here. Is it required? No. What do we suggest? We suggest you put in as little as possible as you can. If you think the seller is going to balk at you putting in 0, then don't do that. Put in 1%. Earnest money is fully refundable during the option period, and we'll go over the option period on paragraph 23, which is on page 8 of this contract. Now, where do you deliver the earnest money to? This is where you would put in your favorite title company. And my favorite title company at this time is Trinity Title. Okay, I'm going to, by law, binding this contract states that I'm going to deliver $750 to Trinity Title. And so within 48 or 2 business days, I need to deliver this money to the title company. And that's what opens title. That's when Michelle over at Trinity Title will open up title and start doing her due diligence on title. Okay. Then we come and you can put in the address, 11833 Dallas Parkway, if you know it. It's good to have all this information, suite 130, and put in Dallas 75248. And then it says buyer shall deposit additional earnest money. I rarely put in additional earnest money, so just leave that blank. Now, paragraph 6 is title policy and survey. Now, a title policy is going to, this is if you're closing at a title company, the title policy is normally paid by the seller on a traditional individual to individual transaction. But you need to talk about this. A title policy is going to run you around 1% of the sales price. Again, that's $750 on this. You need, what I typically do is say, you know what, I'm going to pick up that. You don't even worry about that. And then you would put in the title company again. But this is a negotiable item. I've written it where the seller is paying for it. I just closed on a property in Fort Worth where I typically put in my offer. I've already budgeted that I'm going to pick up the title policy. So it's a negotiable item, but needless to say, let's make it clean and just say the buyer will pay for that, and that's you. Come down here and it talks about that the title policy and the commitment within 20 days after the title company receives this contract, seller shall furnish the buyer to buyer commitment of title insurance. If, guys, I don't want you to worry about it. If there's a title issue, then you're not obligated to close. The seller has to fix any title defects or issues before you're required to close. Now come down here on 6C is the survey. I think this is important. A survey runs anywhere from $350 to $400. So this is something where you can save $350 to $400 by asking the seller, will you look in and provide me with your will you look for your pre-existing survey? Most people, when they buy a house, they don't pay cash, they borrow money, and the lenders, when they borrowed money way back when they bought the house, required a survey. So you definitely want to ask the seller, please look in your original closing documents and find the survey. If a survey is less than, say, 15 years old, most title companies will still use it. If it's over 15 years old, then a lot of title companies will want a new survey. You're paying cash, so the lender doesn't require it. You don't have to get a survey, but I think it's important that I rest easier when there is a survey involved. So I'm going to put in check 6C and put right here within 5 days after the effective date, that's when all the parties sign, seller shall furnish to buyer and title company seller's existing survey. Now it says if it's not acceptable, then the buyer shall obtain a new survey at, and there you can put in buyer's expense. But you definitely want to get the survey if there was a pre-existing survey way back when. And if it's less than 15 years old, then most title companies will still honor it. There's nothing else. If they say, hey, we don't have a survey, then you need to make up your mind, and maybe you check here that within so many days after the contract, the buyer, it's your responsibility. I would really lean on this right here. Check 6C1 and within so many days. Now, objections, buyer may object in writing to defects, exceptions, or encumbrances, anything. And when I'm doing a traditional transaction, I usually put in that I'm allowed to put in a pool. Some houses, because of the setbacks, you're not allowed. It's kind of a higher level. Don't even worry about that. Just leave it blank. There's no, you're not going to get yourself in trouble if you don't put something like swimming pool in 6D. So I don't even know why I mentioned it. Just don't worry about 6D. Come down at the bottom. What do? You got it. Initial. Go to page 3. Put in the address up here, and then we come to title notices. You need to know before you even go on your appointment, is this property in a mandatory homeowners association? Okay, because you need to know that, how to draw up the contract. And that might be something that you ask while you're walking around the property. Do you have any information about the homeowners association? How much? what what kind of community amenities are available, because you need to know. The more you know about the property, the better you're going to be able to package it up and sell it. So here, half the properties, well, most of the newer properties, more recently built properties are in a mandatory homeowners association. So you would check here. And once you check is, then you're going to need to use the promulgated addendum for that. And we've got another video just on how to fill out that addendum. If it's not in a homeowners mandatory, then check is not right here. Scroll down. That's it on page 3. Again, initial. Page 4. Nothing here. And then when you come to paragraph 7 is property condition. This is important. The seller disclosure notice pursuant section 5.008 of the Texas Property Code. You need to have at this appointment, you need to give the homeowner a seller's disclosure document. This is a 5-page document. We will cover what this document looks like in another video. Again, check all these videos, but I'm showing you how to write up the offer, and then there's addendums that you'll need. So what I typically do is I give them that, and I say buyer has not received this notice filled out by the seller, and within 5 days. Okay, so guys, here's the interesting part about this contract. Did you know that if seller delivers the notice, buyer may terminate this contract for any reason within 7 days after the buyer receives the notice? So let's say that you sign the contract today, August 1st, and they don't get you, and your option period is for 7 days on this contract. Well, guys, I want you to know that if they don't get you the seller's disclosure, you have 7 days after they give it. So if they gave you the seller's disclosure, let's say on the 5th of August, within the 5 days, you still have another 7 days to terminate or back out of this contract for any reason. Okay, so it's an interesting thing. I might write up an offer, and I know of investors that do this. They write up an offer that says 0 option period, but guys, there's a built-in 7-day option period for every contract that you write, unless it's a lender. And if it's a lender, then you would check if you're buying the property from an REO or a lender, they are exempt from providing you with a seller's disclosure notice. And so again, I don't want to get into, because I'll write up. I'm gonna show you how to write up an offer when making it to a bank. But I just wanted to kind of mention that you would check this if you're writing an offer to a bank. I'm focused on writing an offer, an all-cash offer to an individual seller, and that's where you check right here. Put in, and then put in however many days you want to give them, 5 days. And it's helpful if you can actually provide them with a 5-page document and leave that with them so they can fill it out to the best of their ability. Then you put in 7D is acceptance of property condition. Always check that we accept the property in its present condition. Guys, we sold them on convenience and as is and all cash. So don't put in that, well, unless you see something that you really are worried about or needs to be fixed prior to closing, just put buyer accepts the property in its present condition. And that's it for page 4 of the promulgated contract. Now let's go to page 5. Here on the very top, it's residential service contract. This is again for a traditional owner-to-owner transaction where you're not paying cash. Typically, the buyer wants some type of service contract, and this is if one of the major components like the HVAC went out. The seller typically says that they will provide, or the seller will provide a service contract, a home warranty. Another word for this is a home warranty. You guys are writing an as-is offer, all cash. Don't worry about filling in anything here. Then on paragraph 9, there's nothing on paragraph 8 that we need to fill out. Paragraph 9 is when are we going to close? Typically, we want you to close, we want you to write up offers that say we're going to close in 2 to 4 weeks. So you're going to have to You're going to have to listen to the seller and and determine what date you put in there. But I would say if you're writing an all cash offer at a discount, you need to be prepared, or the end buyer needs to be prepared to close in 2 to 4 weeks. So fill that out accordingly. I could put in 8/15/2011. Okay, so it just plugs it in, August 15th, 2000. Let me change this and put right here. Okay, and now we've got it, August 15th, 2011. Now, when do we take possession? Possession is typically upon closing and funding. So you would check this box right here. You're typically not going to lease the property out prior to closing, so upon closing and funding, check that box on paragraph 10. Special provisions, this is where you would put in, for me, because I'm a licensed agent, I'm going to put buyer holds a real estate license. Now, most of you guys are not licensed, so you will not have to put that in. But because if you are a licensed broker or real estate agent, you have to disclose that. So definitely put that in, special provisions, to cover your rear end. Then that's it on page 5. And now we're going, again, initial at the bottom. Page 6 is settlement and other expenses. You're writing an all cash offer, so you would leave this blank. Really what this is if you are going to ask the seller to pay for some of your closing costs. Well, we're kind of going the opposite direction. We're paying for all the closing costs. So you definitely, you don't need to fill it in 12 and put anything in there. Down here, prorations. The big thing is, I think it's important that you mention this, that although you're paying for closing costs, we're not paying for the prorated tax amount. When you close on the house, the seller needs to understand that they're going to pay for 8 months of taxes, 10 months of taxes, because they've owned the property since the first of the year. So they need to understand that there will be some deductions at the closing table for a proration of taxes. The city, the county, the school district, the title company will prorate what the annual taxes are and then give you a credit and debit the seller. The only other thing on page 6 is mediation. It's up to you. Do you want to mediate if there is a problem, or do you not? Do you just want to, both parties have the right to hire attorneys and just sue? It's pretty common that most people will click or check will mediate. If there is a dispute, both parties agree to go to a mediator and try to resolve the problem before they hire the legal team. So it's up to you. You use your judgment, but I typically put in will. And that's it on page 6. Again, initial. Then page 7, nothing on it. This is all promulgated, so we don't need to fill out anything really until the very bottom. And this is where our notices to be sent. So this is where you would put in, because on the buyer I would put in George Roddy Jr. and or assigns, and then I would put in my address, 4204 Pepper Bush, Arlington, whatever your address is, and then put in your phone number and 214-593-0074, your fax number, and your email. All this is are there any notices or any title companies? Most likely you would change this and give this to the title company once you assign it, because you want all notices to go to the end buyer, not necessarily yourself. And here you'd put in Tim and Jennifer Harridge, fill in their address, their phone number, their fax, and their email. And then everybody initials on page 7. That's it. Page 8 is, we need to think about this before we write this up. We're not going to have any financing addendums. We're not going to have any seller financing addendums. We're going to have we might have an addendum for mandatory homeowners associations, so we might need to check that. It depends on the property. And then the addendum for backup, we're not going to have any of these. again, when with an all cash, we're going to most likely not have a short sale. That's a different video. And the only other thing is we need to check this box down here, because when we're writing an all cash offer, we're going to attach addendum A. So I'm going to show you, Tim is going to give you a video on how to fill out the addendum A, and that goes with this offer. Okay, so you've got a 9-page promulgated contract 20-10, and then you're going to have an addendum A, and he's going to give you a video. So watch the video, but it's really 2 parts. You might have some more stuff here, like you might have several things. So you could have lead-based paint down here. Disclose if the house is built prior to 1978, then you're going to need to get the seller to fill out the lead-based paint. So really, homeowners, lead base, and addendum A if you're writing an all cash offer. If the house was not built or was built after 1978, then don't worry about this. And you might not have a mandatory homeowners association, so you won't need this, but you will definitely need addendum A. Last thing is termination option. This is the most powerful paragraph in the 9-page document. It says, for nominal consideration. Now, what is nominal consideration? That's whatever, that's $10 or more. We're going to tell you to put in $20, and we want you to ask for 7 days. Can you get away with more? Absolutely. If there's time, then try. You want this to be this date or time frame to be as long as possible. You could make it 30 days if you want. This gives you the unrestricted right to back out of this deal. And you're going to pay $20. Now, $20 is less than what's normal, but it's whatever the seller and you decide. So what I would say is, at a minimum, put in 7 days. Now remember, even if the seller says, we don't want to give you an option period, you could always make your offer less. But the contract said, you remember a few pages ago about the seller, I think that was on page 3 or 4. Let's come back. Yeah, it's right on page 3. No, page 4. Right here, you have a built-in 7-day period to terminate, even if you don't put anything down in the option period right here on page 8. Okay, so $20 for 7 days and will be credited. We want the $20 to be applied towards our sales price. Now that's really it. And then on paragraph 24 is consult an attorney. We don't have an attorney, so you're going to leave that blank. Maybe the seller does. I've never filled this in for a seller. And then the big thing is everybody signs, okay? And this is the effective date. And the effective date starts the day after. So if I wrote a contract today, August 1st, the first day of the option period would start August 2nd. So it's 2nd, 3rd, 4th, 5th, 6th, 7th, and 8th. This, I've got to find an investor to buy this by midnight on the 8th. Okay? Because if you don't have that, then you're at risk of losing $750. That plus they have the right to seek specific performance. So right here on page 2, you put up $750. That's gone. I mean, they can take that if you don't terminate your contract and don't close on August 15th. So it's important that you understand that you definitely need to terminate this offer before, if you don't have an end buyer in mind. Finally, you pick the date, you put in today's date, or once everybody signs. And again, you can't put in a date unless everybody is signed. So if you're sitting across the table, you can do it right then and there. Everybody signs. But if you fax or email this and they sign, once you sign, that's the effective date. And let me give you an example. I purchased the property 3 days ago, and the seller signed this contract on the 14th of July. But I didn't get the contract and I didn't sign it until the 18th. So I scratched through the 14th and put in the 18th, because until I sign it and get it back to her, we don't have an effective date. So it's important that you have the seller sign, you sign, and that's once all parties have signed, the last person to sign it is who puts the effective date on the contract. So when you one thing that you might want to do is if you write an offer and you sign this, and you should submit an offer, one thing that you might put, and this is what I've learned through doing traditional transactions, is put a number 2 right here. To back up a little bit, but put this in at buyer's option. This offer will be null and void if not accepted by 11/3/2011 at noon. That's your option. You can still continue with this, but at least you don't have all of these offers floating out there. Let's say that you met with the seller and husband and wife, and they wanted to look at your offer. They said, "You know what? Draw it up. We'll take a look at it." Well, you do that. You send them a follow-up letter and you send them this offer. You need to put this in here to protect yourself, because if you don't, then they could accept it at any time. But if they accept it after the August 3rd, it's okay because it's at your option. So at buyer's option, this offer will be null and void if not accepted by 11/3/2011 at noon. And that's how you handle not having any floating contracts out there, because you don't want to get dropped in the grease. Going back, I just want to make sure I've got everything on page 8. Yeah, we've got everything there. Now I go to page 9. Page 9 has the address. It's got broker's information. If there's any brokers involved, then you need to fill that out. In most cases, you're not represented, so you're not going to put in any buyer's information here. This is really what the listing broker has agreed to pay the buyer's agent. Well, we don't have a buyer's agent, so you don't need to fill out anything here. Okay, the last 2 things on page 9 is the option fee. If you do give them an option money, you need to get a receipt of it. You need to get the seller or the broker to sign this. So in this case, we gave $20, and then you'd put check, or we could put cash, and have the seller, and we would put Tim and Jennifer Harridge, and then date it. So right here you'd put the date, and whatever date that was, today's date, and let's just put that in. And then and they sign that. And then the last thing is you take this contract and your $750 as earnest money, and you deliver this to the title company, and the title company will receipt. They'll check this and they'll do everything. You don't need to fill in any of this. You definitely need to fill in the option fee receipt, but you don't need to fill in this. 2 things, both the option fee and the earnest money need to be delivered within 2 days of the effective date. You want this to be a valid contract, so to be forthright, you need to get the $20 to the seller, and you need to get the contract delivered to the title company within 48 hours if you want a valid contract. Well, that's it on writing up an offer all cash for an individual. I hope you guys have learned a bunch, and specifically how we want you to fill out these contracts. Post any comments and questions below, and we will see you on the next video.